Good afternoon. My name is Rick Hassan of the UC Irvine School of Law, and I want to welcome you to the 4th annual Supreme Court Term in Review event. This event brings together the law school, the university, and the larger legal and broader Orange County community to talk about one of the country's most important and influential institutions, the Supreme Court. Today we have an outstanding group of scholars, lawyers, and journalists. I want to thank the UCI law staff for the support they've given for this event, especially our events coordinator, Brittany Rodriguez, and our communications staff, Colleen Tarakani and Iris Yokoi. I want to thank the law school and Dean Chemerinsky for supporting this event. The first year we had this event, we had 100 in the audience. The second year, 200. Last year, over 300. This year, I think we had over 500 RSVPs, and the room is filling up. So we'll keep looking for larger venues as people have interest. Each term of the Supreme Court, beginning the first Monday in October, is different, with some terms being more important than others. During our first annual event in the summer of 2011, one of our initial panelists, who's here with us again this year, Slate's Dahlia Lithwick, remarked on the dullness of the October 2010 term. Last year, of course, brought us a health care case. We had a term that UCI Law Dean and panelist Erwin Chemerinsky called amazing, including rulings on same-sex marriage. This term falls somewhere between dull and amazing. A large span, to be sure. Some cases were big. Some cases could have been big, but were not. Some people touted the court's unanimity, and others thought it overrated. At least one case, Hobby Lobby, is either a monumental case or no big deal, depending on who's doing the speaking and analyzing the case. Despite the high rate of 9-0 decisions this term, many decisions were controversial. Many were hard to understand. Fortunately, today we have assembled an all-star cast to help us sort through everything. Indeed, short of having the Chief Justice himself here, it's hard to imagine a more qualified group to discuss the court's term. We have a packed schedule, and so I'm going to give a brief introduction to our 6 panelists. I'll introduce them in alphabetical order, although they're not sitting in alphabetical order. UCI law professor Jennifer Chacon conducts research in the fields of immigration law, constitutional law, and criminal law and procedure. As a teacher of both criminal procedure and immigration law and policy, she's particularly interested in questions arising at the intersection of these fields. Chacon came to the UC Irvine School of Law after teaching at UC Davis and serving as an outside advisor for the immigration transition team of President Barack Obama. Erwin Chemerinsky is the founding dean and distinguished professor of law and Raymond Pryke professor of First Amendment law at UC Irvine School of Law with a joint appointment in political science. Prior to assuming this position in 2008, he was the Alston Bird Professor of Law and Political Science at Duke University. Previously, he was professor at the University of Southern California Gould School of Law, including as the Sidney M. Ermis Professor of Public Interest Law, Legal Ethics, and Political Science. He is the author of 8 books, including The Case Against the Supreme Court, just to be published by Viking in 2014, and more than 200 law review articles. Jeffrey Fisher is a professor at Stanford Law School and co-director of its Supreme Court Litigation Clinic. His academic and Supreme Court work runs the gamut of federal, constitutional, and statutory matters, but focuses on constitutional criminal procedure issues. Fisher has argued 23 cases in the Supreme Court, including representing the petitioners in Crawford v. Washington, Melendez-Diaz v. Massachusetts, Blakely v. Washington, and Kennedy versus Louisiana. In 2006, the National Law Journal named him one of the 100 most influential lawyers in the country, the youngest person on the list, and he has since remained on the list. Dahlia Lithwick is senior editor at Slate, and in that capacity writes Supreme Court dispatches and jurisprudence column. Her work appeared in the New York Times, Harper's, New Yorker, the Washington Post, and Commentary, among other places. She won a 2013 National Magazine Awards for her columns on the Affordable Care Act. And this is not in her official bio, but Justice Ginsburg, in an interview with the Wall Street Journal, recently said she was kind of spicy. That's true, isn't it? Yeah. Burt Rhine, a founding partner of Wiley Rhine LLP in Washington, D.C., is widely recognized as a leading antitrust and commercial litigator and international law expert. He specializes in using constitutional law issues to challenge emerging legislative and regulatory policy, and represented the prevailing parties in 2 historic cases decided by the Supreme Court in 2013, Fisher versus University of Texas and Shelby County versus Holder. He's been named a Legal Times visionary, one of a select group of lawyers whose business foresight or legal acumen has expanded their firms, advanced the law, or improved government. I'm cutting these down. There are many accolades here, but I want to actually get to the program. Mark Sherman is a journalist who has covered the Supreme Court for the Associated Press since 2006, a period that has included blockbuster decisions on health care and same-sex marriage and big changes in the court's membership. He's previously written about the Justice Department, health care, and national politics for more than 25 years as a reporter based in Washington and Atlanta. Earlier in his professional life, Sherman worked for the Atlanta Journal-Constitution, briefly as a Foreign Service officer, and was a copy boy at the New York Times. To keep the program moving, I've asked each panelist to speak for no more than 7 minutes on one of the court's cases and on a theme of the court's term. That will leave us with about half the time for the panelists to engage with one another and to take questions from you. At question time, you'll be able to queue up to ask questions, but to ask a question, we have 2 requirements. First, it must be brief, and second, it must be a question. I will be ruthless in cutting people off to keep things moving. If you're watching via the webcast, you can submit your questions on Twitter using the hashtag UCILawSCOTUS. And with that, we're going to turn to the panelists, and we'll work our way not in alphabetical order, but down the row, beginning with Dahlia Lithwick.
Thank you, Rick, and to UCI, and to all of you for coming out on this magnificent day, although I've been led to believe that every day is a magnificent day in Irvine, and so maybe you're not sweating it being indoors the way I am. But, I'm going to talk about actually 2 cases in 7 minutes, and I'm going to thus not do them justice, but we'll kind of get them out there, and then we can talk about them in a deeper way in the discussion portion of the show. And the 2 cases I'm going to talk about are Schuette, the affirmative action case that came out of Michigan, and the Town of Greece case, the legislative prayer case that came out of Greece, New York. So just very briefly, Schuette versus Coalition to Defend was a 6-2 decision. Elena Kagan recused herself from the case. And this case comes up out of Michigan State, which has determined in the wake of other affirmative action decisions that they should ban the use of racial preferences or affirmative action in all sorts of things, but for our purposes in public colleges and the selection of students in public colleges. And this is done by way of a voter ballot initiative called Prop 2. 7 states have similar bans on the use of affirmative action, and it's important to understand this case is not an affirmative action case. The question is the flip of what we're used to, which is, can a state ban the use of affirmative action? So it doesn't track the cases that come before. And the appeals court strikes down the Michigan ban on affirmative action, and the court, as I said, by a margin of 6-2, finds that the ban is permissible, that states can, going forward, ban the use of affirmative action and racial preferences in colleges. And the nut of the case, the doctrinal part that's really interesting, is this turns on a very, very esoteric thing called the political process doctrine. So this doesn't turn on the ways that we think about affirmative action. It turns on a case that really is a 1982 case that largely said at the time that you cannot use political systems or processes to disadvantage minority groups. And this is a sort of an outlier, and this case comes up under that, and Justice Kennedy, writing for the court, says, you know what, no, this isn't that. He doesn't overrule the idea of the political process doctrine, but he says this isn't what happened here. And then the interesting part of the case, and maybe we can talk about later, is not just that he sets aside the political process doctrine for analyzing the case, but the conversation that happens between the majority and the dissent about how, not just how we think about race, but how the court is going to talk about how we think about race. And so Justice Kennedy, writing for the majority, upholding the Michigan ban, writes, quote, "This case is not about how the debate about racial preferences should be resolved. It's about who should resolve it." And this really becomes a case in which the majority of the court says the Michigan voters have appropriately made a determination, and the determination should stand, and we should defer to that judgment of the voters. And then there's a lot of conversation in his opinion where he talks about the dangers of identifying racial groups and making what he thinks are sweeping determinations about the racial distinctions. And so he says of racial identity, quote, "It cannot be entertained as a serious proposition that all of individuals of the same race think alike," and goes on to say that when you have these conversations about race and affirmative action, it leads to, quote, "demeaning stereotypes," which in turn leads to what he calls racial antagonism and conflict. So in effect, what he's saying is this entire conversation really risks creating stereotypes and judgments about racial groups that stigmatizes and undermines those races. The other notable thing about the case, and the thing that probably sucked up a lot of airtime, was a dissent, the likes of which we have never seen at the court, 58-page dissent by Justice Sonia Sotomayor, who is joined only by Ruth Bader Ginsburg in dissent in this case, and her dissent is more or less a straight-on importing of her own book. Her life story, and how, in her view, Chief Justice John Roberts' famous formulation that the way to get beyond race in America is to get beyond race has to be wrong. And in her view, the way to get beyond race is to talk in a nuanced and meaningful way about race. And her 58-page real barnstorming dissent more or less expresses in her own view what it's like to be a minority in America, and that while it may be well and good to say we've just gotten past that in America, in her view, we haven't even started to get past it. And it's a really, I think, interesting conversation between the majority and the minority about where we are in terms of thinking about race in America. The other case that I said I would talk about briefly is Town of Greece. And this is a case that comes from a little town in upstate New York called Greece, not on the Adriatic. And in this small town, they have been opening town meetings, legislative sessions, with, quote, a legislative prayer. And this is a longstanding tradition that goes all the way back to the founding, that you can open legislative sessions with a prayer. In Greece, these prayers are solemnized by a member of the clergy, and it just so happens that over the course of years and years and years, all but a handful of the prayers are led by Christian faith leaders. So a suit is brought by two people, one an atheist and one a Jew, who say that they don't really like going to their town council meetings and having every single meeting be solemnized by a sectarian prayer that is not of their faith. And the Supreme Court more or less, pardon the pun, blesses the idea of sectarian prayer at legislative sessions and says, this is a 5-4 vote. Again, Justice Anthony Kennedy writes for the court, in effect says, A, this is a long-standing tradition, that it goes back to the founding, that the test that Sandra Day O'Connor used to use, the so-called endorsement test, is not the test unless minorities feel coerced or demeaned or threatened or cajoled by the prayer that's going on. The prayer is acceptable. And again, barnstorming dissent by Elena Kagan, talking about what it is to be a religious outsider forced to sit through years and years of sectarian prayer. I will just say that my theme for the court, for the term, is I think that there was a huge amount of ruckus over the degree of unanimity. 67% of the cases this year, the highest in decades, decided unanimously. And I think we want to be very careful about talking about cases that are really unanimous, like Riley, which is the cell phone search case that Jeff's going to talk about, truly a unanimous 9-0 decision. And the term I have coined, which is faux-nanimity, which is fake unanimous cases, which is a great swath of cases in which the justices look like they're agreeing, but there is a furious, enraged concurrence, and in one case, Justice Scalia writing a concurrence that says, I won't be part of this specious unanimity, just as he becomes a part of this specious unanimity. So I will end there. Thank you for having me.
Thank you. Good morning. I wish Dahlia hadn't been so disciplined, so then I could talk longer. But if this term is characterized by cases of great importance in the dull, I unfortunately, prior to the decision, selected one that was dull, but I'm going to talk about it anyway, and that's the case of Palm Wonderful, so named, versus Coca-Cola. But I thought it was of particular interest to this audience because it's about food labeling and the accuracy of food labeling and the kinds of misleading practices that might be adopted in a food label, even though that label is regulated by the FDA. And there's been a great deal of this food litigation here in California, so I thought, well, that's appropriate, and this might create some really interesting stuff in the Supreme Court. You can judge for yourself whether it did. But just to recap the facts very briefly, Palm Wonderful sells something called pomegranate blueberry juice. And it's a mixture of pomegranate and blueberry juice, and they advertise it very heavily, and they advocate the curative and restorative and marvelous properties of pomegranate juice, which got them in trouble with the FTC, but that's a sideline. In any case, Coca-Cola then decides that they're going to compete with this, and they market something called pomegranate blueberry flavored blend of 5 juices. And much to the irritation of Justice Kennedy, this stuff turns out to be 99.4% apple and grape juice, which are a lot cheaper, and they're sweeter and they taste better, and then a little dash here of pomegranate, a little dash of blueberry, and a tiny little smidgen of raspberry juice. Notwithstanding that, the letters pomegranate and blueberry are up there on the label. They're pretty prominent. The first thing you would notice, where it blends a little smaller, flavor's a little smaller, blends a little smaller, and it kind of diminishes from there. And on that front piece of the label is a picture which shows, it does show an apple and a grape, but it also shows a pomegranate, a blueberry, and a raspberry. Now, if you turn the panel around, because the FDA regulates the first panel, the front panel, and the rear panel, there's a listing of the juices in their order in which they are used in the product. So you could tell that the principal juices are apple and grape, but you have to turn it around. And there's also a nutritional label that tells you. Turns out, so Palm then sued, taking great offense at Coca-Cola free riding their false publicity, and said, how dare you, we're going to sue you for diverting business from us because you're deceiving consumers who think they're getting the real pomegranate, but they don't. The case went up through the Ninth Circuit, which said, well, look, this is all regulated by the FDA. We really want nothing to do with this. Go away, Palm. We don't want to deal with you. I think that's a fair summary of the decision. More elegant words. But in any case, so it goes up to the Supreme Court. Now, the Supreme Court then is faced with a tension. They have 2 federal statutes because Palm brings its case under the Lanham Act, which allows a disadvantaged competitor to sue for business injury. That generally is where you're being disparaged, but here it's sort of translated through the customer. The customer's fooled, I lose business, you gain business at my expense. And the court then is faced with 3 contrasting views of how the existence of the Lanham Act, and where Congress says you have a remedy, can be reconciled with the Food, Drug, and Cosmetics Act, which says the FDA will tell you what to put on that label and will determine whether it's false and misleading, an authority they have, and will also be able to determine when the consumer is adequately apprised to make an intelligent buying decision. So what do we get? One extreme, Coca-Cola says, well, it says the FDA is in charge. What we did was an authorized name. It wasn't compelled, but it was authorized, good enough, go away. Other extreme is Palm, which says these are 2 different statutes, and they have to coexist, meaning we can do whatever we want on the Lanham Act, and whatever you do under the Food, Drug, and Cosmetics Act, that's your license to sell in interstate commerce. It's a floor. It's not a ceiling. Why do you even need to look at it? And of course, the Solicitor General comes in the middle, and he says, well, got to be balanced here. I have to protect the FDA because I'm the government. So where the FDA has specifically talked to a point, like can this thing be called pomegranate blueberry flavored blend, well, you can't attack that because the FDA made a judgment that that was proper and authorized. But you can attack the rest of it because they didn't tell Coca-Cola to do what they would with the rest of it. So now the Supreme Court has these 3 positions, and they say, because they are irritated, really irritated by that label, Justice Kennedy says, I was deceived. How could an average person figure it out? I mean, got me, and driven by that emotion. There's an 8-0 decision, Justice Breyer being recused. I guess he drinks this stuff. And the decision says Palm wins, Coca-Cola loses. And so what the court says is, well, there are two different statutes. Congress never said in the Lanham Act that it has to give way to the Food, Drug, and Cosmetic Act. They had the Food, Drug, and Cosmetic Act there, and they amended it over the years. They never said no Lanham Act, notwithstanding the fact nobody would ever dream of it. But they never said it. Therefore, it's, even if we had to reconcile the two, and we don't say whether we do need to reconcile the two or don't, but even if we did, it would come out Palm's way. And basically what they say is the Lanham Act has independent, and by the way, it will reinforce the concept of false and misleading, because we all know the FDA really is overwhelmed, doesn't really do anything, and we're going to make sure that there are good lawsuits out there that will, in fact, discipline people who want to mislead consumers through the label. Now, what's quite interesting in the case, just how the Supreme Court operates, and it goes to what the Supreme Court does. Part of the Food, Drug, and Cosmetic Act, the Labeling Education Act, has a clause in it that says no state may establish, and in any way, a requirement that's different from the requirements that are in the Food, Drug, and Cosmetics Act. So that's what we generally call preemption. States can't do it. Leading to the question, well, isn't it curious that here's a lawsuit that says the consumer's deceived and I'm hurt, so I have the Lanham Act. But the consumer, who would ordinarily bring suit under state law and can't bring suit under the Lanham Act, they have no remedy. So the person protected is your competitor. So I will say, since I'm supposed to wrap it up, what it showed, I think, is typical of the Supreme Court. They are partially fact-driven. If they don't think the case has dramatic social implications, they kind of sit like a common law court. This is bad stuff, and we got to get rid of it. They can distort anything. They said the FDA regime is only concerned with health and safety. Well, that's bogus, because forever in the food area, it's been concerned with standards of identity and other things that allow consumers to make reasonable judgments. But if you're the Supreme Court, you can say it. So it's true from now on and forevermore. And they can say, well, we'll decide tomorrow whether consumers could directly remedy the same thing that they are indirectly being helped by Palm to remedy. It's a curious case. I think it's indicative of the fact that you have socially hot-button issues where the court will honestly divide, and that's where you get the unanimities and all the rest, where they kind of fudge a little bit, not let's decide this today. It's a very cautious court in that regard, and I will cease.
Good afternoon. I want to thank Rick for inviting me to be on this August panel. I will try to take as little time as possible so I can see the balance of my time to all the wise people around me. I was asked to identify the theme of this term, and I guess Rick kind of hit the nail on the head when before the panel we were talking, and he said it's sort of the year of the dud. And I think that's right. There were some really interesting, fascinating decisions, but there were a lot of cases that had the potential to be big and explosive that actually just didn't explode. And the court resolved certain questions on fairly narrow grounds and turned away from deciding some of the more controversial questions. And so the case I picked for two reasons. One is because the facts are really fun, and the other is because I think it sort of embodies this notion of the cases that didn't explode. And I guess the sub-theme here is that objects in the mirror may be closer than they appear. So if we're thinking about looking at the term retrospectively and thinking about what happened, it's possible that some of these decisions that seem small or narrow are planting seeds for future litigation and future cases that will be important and monumental. And I think in some ways Bond contains the seeds of those themes too. And so I'll talk a little bit about Bond, a unanimous holding that has a lot of interesting undercurrents. I think fits very well into Dahlia's notion of phonymity. This is a case involving a woman scorned. This woman, Carol Ann Bond, was a victim of a cheating spouse. She received the happy news that her best friend was pregnant, followed by the not so happy news that her husband was the father, and this resulted in some anger on her part, understandable, I think. But the steps that she took as a consequence of that anger were steps that probably went beyond what many of us would do in this circumstance. She decided to use poisonous substances to try to at least irritate the skin of the woman with whom Bond's husband had sexual relations. And so she was prosecuted for a number of things, but among other things, she was prosecuted for violating a federal law prohibiting the use of chemical weapons. Now, the prohibited conduct under the federal statute is actually very broadly defined. A chemical weapon is, quote, a toxic chemical and its precursors, except when intended for purposes not prohibited under this chapter. And a toxic chemical is defined as, quote, any chemical which through its chemical action on life processes can cause death, temporary incapacitation, or permanent harm to humans or animals. The statute goes on to exempt the use of these substances for, quote, any peaceful purpose. Now, it's important to note that this federal statute on chemical weapons was enacted to implement the Chemical Weapons Treaty. So Bond made a few different arguments about why this shouldn't actually apply to her, two of which I'm going to highlight here. So first, she argued that the enforcement of the criminal law, commonly referred to in the parlance of constitutional law scholars as the police powers, is a power that belongs to the states. And the federal government can't abrogate that power except in cases where the federal government is empowered to act. So she's saying that the statute exceeds Congress's enumerated powers under Article 1 of the Constitution, and it violates the 10th Amendment because this is an area that the states are supposed to be regulating, not the federal government. So this is a classic federalism argument, but federalism argument that's kind of putting into the test the scope of Congress's treaty power. The federal government, of course, argued that it did have the power to enact this statute because enacting the statute, among other things, is necessary and proper to its ability to enact treaties. The court could have decided the constitutional question about the interaction between this treaty power and the federalism concerns that Bond raises. And that is the kind of the potentially explosive, really interesting decision that we could have had in this case. And instead, the court went narrow. And this, I think, is kind of how they get to phononymity in some of these cases, and just, I think, embodies a lot of what's happening in the court here. Using the canon of constitutional avoidance, the majority opinion, which was written by Roberts and joined by Kennedy, Ginsburg, Breyer, Sotomayor, and Kagan, construes Congress's statute, the statute that they wrote about the chemical weapons, about use of chemical weapons narrowly. So they say, actually, we don't think this was the use of chemical weapons. We don't think the conduct that she engaged in was actually the conduct that's prescribed by the statute. So we don't think we have to actually reach the broader question of whether Congress could enact this kind of a statute, because we don't think that the conduct that she engaged in was the conduct that was actually covered by the statute. So they read this narrowly. They say the substances she's using are not chemical weapons. It's not what we mean when we say chemical weapons. So she shouldn't have been prosecuted in this way. And by construing the statute in this narrow way, the court doesn't have to decide the scarier, much more interesting questions about treaty power, the 10th Amendment, and federalism. Justice Scalia is sort of devastating in his effectiveness in poking holes in the majority's approach to this statutory interpretation. He says, actually, chemical weapon is defined. We have the definition, and this really fits quite nicely under the definition. And I think he has a persuasive statutory argument. On the other hand, the majority is sort of persuasive when they say, I don't really think that's what this statute was about. And so it provides a nice out for them. Scalia would have decided the constitutional question, obviously. He thinks her conduct is covered by the statute, and he would have concluded that the necessary and proper clause doesn't justify this sort of domestic lawmaking under the guise of the treaty power. Justice Thomas, in his concurrence, alternatively says, we really should be talking about the substantive limits on the treaty power more broadly. Maybe this isn't what Congress's treaty power is about. Maybe their treaty power doesn't really extend to this sort of domestic regulations. And Alito agrees with him here. So they don't think treaties extend to this sort of thing at all. But the court's saving construction allows them to not have to go down the road at all. Now, this, of course, raises all kinds of interesting questions that it doesn't answer about the scope of the treaty power, about the way that the treaty power interacts with state police powers. And the court may, at one point, have the opportunity to resolve those questions. And that's why I say these cases may be about objects in the mirror being larger than they appear. We have a case that's ultimately a small case, a statutory construction case, that really could be something bigger in the future. And the questions will come up probably in future litigation. So that's the theme, and that's the case that I'll focus on. There are lots more, and I'm hoping we can continue the discussion in the next hour.
I want to take a moment and speak as Dean and welcome all of you to UCI Law School. I want very much to thank Rick Hassan, who planned and put the program together. I want to thank Brittany Rodriguez, who is handling all of the logistics of the program. And I very much want to thank all of these wonderful panelists who took time from their busy schedules and traveled to come be part of this program. My theme for the term is that there were many decisions that appeared narrow, but in reality were very broad in terms of their implications, in terms of the litigation they're likely to lead to, and their social consequences. I don't think this was a term of duds at all, and my example to show that is a case that came down on Monday, June 30th, Burwell versus Hobby Lobby. It's a case that received a great deal of media attention, but I was also found in talking to various people, it's a case that's much misunderstood. Congress passed a statute that called on the Department of Health and Human Services to promulgate regulations that would mean that employer-provided insurance would include preventative health care coverage for women. Health and Human Services, working with experts, promulgated the regulations. Included among what was to be provided by employer-provided insurance were 20 kinds of contraceptives approved by Health and Human Services and the Food and Drug Administration. The regulations promulgated by Health and Human Services were actually more nuanced than the media has made it seem. For religious institutions like the Catholic Church that oppose contraception, they do not have to provide such insurance coverage for their employees. For nonprofits that are affiliated with religious institutions, like, say, a Catholic university, it can get out of this responsibility by signing a 2-page statement, and then the insurance provider would still have provide contraceptive coverage, but at no cost to the employer. But when it comes to for-profit companies, they do, if they provide insurance to their employees, have to include contraceptive coverage. Many lawsuits were brought challenging this. 2 made their way to the Supreme Court. One involved Hobby Lobby. It's a company that's headquartered in Oklahoma. It has 500 stores. According to the Supreme Court, it has 13,000 employees. According to Wikipedia, it has 21,000 employees. You can decide who's more credible there. The other challenge that came to the Supreme Court was by a company called Conestoga Wood Specialty. It's out of Pennsylvania. It makes custom woodwork like cabinets. Each claim based on religion that it violated its religious beliefs to have to include insurance coverage for at least some of the contraceptives. The Supreme Court, in a 5-4 decision, held that it violates the Federal Religious Freedom Restoration Act to require that close corporations provide insurance for employees that includes contraceptives that they find religiously objectionable. I want to emphasize that the court's decision was not, contrary to you might have heard, based on the Free Exercise Clause of the First Amendment. It was based on this federal statute, the Religious Freedom Restoration Act, adopted in 1993. Justice Alito wrote the opinion for the court. He was joined by Chief Justice Roberts, Justice Scalia, Justice Kennedy, Justice Thomas. Justice Kennedy wrote a short opinion concurring. Justice Ginsburg wrote the primary dissent. Justice Alito, writing for the court, said that close corporations have religious beliefs and religious free exercise that's protected under the Religious Freedom Restoration Act. He said the Religious Freedom Restoration Act protects persons, but it doesn't define persons. He says there's a federal law called the Dictionary Act that defines persons to include corporations. And he says corporations can also have religious beliefs and religious free exercise. He said these individuals could have created a business or a partnership based on their religion. They shouldn't have to give up religious free exercise by forming a corporation. And he says as to close corporations, family-held businesses, they can claim religious free exercise under the Religious Freedom Restoration Act. Next, Justice Alito, writing for the court, said it substantially burdens free exercise of religion under this statute to require that the employers write insurance coverage for contraceptives that they find to be religiously objectionable. Justice Alito, writing for the court, says that the court would assume without deciding that there's a compelling government interest in making sure that contraceptives are available for women. The Supreme Court has said since 1965 in Griswold versus Connecticut that there's a fundamental right to purchase and use contraceptives, but Justice Alito said this isn't narrowly tailored. There's less restrictive alternatives. Congress could directly provide contraceptives or contraceptive coverage to women. Or the alternative that Congress created for nonprofits affiliated with religions could be used, where they just have to file a 2-page statement, and then the insurance provider provides coverage at no cost to the employer. Justice Ginsburg wrote the dissent, and she vehemently disagreed with every aspect of Justice Alito's majority opinion. She disagreed with the interpretation of the Religious Freedom Restoration Act. She disagreed that a corporation, a fictional entity, can have religious beliefs or religious free exercise. She disagreed that it was really a burdening of the company's free exercise rights to require that it just provide insurance to the employees, for the employees have an option. She disagreed as to whether there's less restrictive alternatives. I think this case is quite important, again, to use the language from a moment ago, not at all a dud, because it does so many things for the first time in American history. This is the first time in American history that the Supreme Court has ever said that a for-profit company can have free exercise of religion and religious beliefs. I know if I want to run a business, I can do so by my religious beliefs, so long as I don't violate other laws. I create a corporation to protect myself from liability. I am liable, so long as the corporation is separate from me, only to the extent where I invest in the corporation. Now the court is saying that the owners of the corporation can imbue their religious beliefs onto this separate fictional entity. Now the holding of the case is about close family-held corporations, but the reasoning would apply to all corporations. In fact, the only limiting principle that Justice Alito gave was say, well, he doesn't think that other corporations would want to exercise religion, but that's certainly not a reason why they could not make such claims. This is the first time in American history that the Supreme Court has ever found a violation of free exercise of religion by helping somebody else do something. No one here is required to use contraceptives, obviously. No one is prohibited from using contraceptives. Hobby Lobby, Conestoga Wood Specialty could still speak against it. All they're doing here is providing insurance that has this as an option. I don't know where the stopping point is. What of the employer who's a Christian Scientist who objects to all traditional medical care? Does it now not have to provide any health insurance? What the court says burdens religion here is that indirectly the employer's money is going to provide for contraception. Well, could an employer then say as a condition of work that none of the salary paid could be used for abortion or contraceptives, and the employers could then monitor that? This is the first time in American history that the Supreme Court has ever found that in the name of free exercise of religion, a person could impose an injury on somebody else. The other cases about free exercise have all been about, can a person use a drug like Waska or peyote in the name of religion? Or does somebody have the right to get unemployment benefits? They quit their job on the basis of religion. Never before has the Supreme Court said that somebody in the name of religion can impose an injury on someone else. So I think what you're going to see is employers arguing that they have the right to discriminate on the basis of gender, if they have a religious belief that women with children shouldn't work outside the home, or they should be able to discriminate on the basis of sexual orientation. Justice Alito had one sentence saying, well, someone should not be able to claim a right to discriminate based on race because of religion, because there's a compelling interest in stopping race discrimination, and there's no less restrictive alternative. But it's interesting he mentioned just race. Was that meant to leave the door open to those who want to discriminate based on gender, to discriminate on the basis of sexual orientation? All of these are the claims that are going to be litigated in the future. The case is important for all of the women across the United States who will now be denied access to contraceptives. But I think the case is also important in opening the door to much more violation of rights based on claims of free exercise of religion.
I was going to say, it's going to keep going on. Just wait for the signal.
Well, I'm going to talk a little bit about a case that turns on a dime. Well, actually, it turns on a dime-sized antenna. Actually, it turns on thousands of dime-sized antennas. In truth, it turns on a portion of the Copyright Act. And it's the portion of the Copyright Act that gives to a copyright holder the exclusive right to transmit a performance of that copyrighted work to the public. This is the case involving the latest skirmish, in what Justice Scalia called the long-running battle over the delivery of copyrighted television programming. And it's the case between the television networks and Aereo, which is an internet startup company. And Aereo came up with a way to allow its subscribers to stream nearly live with just a few seconds of delay local over-the-airwaves television programming to your laptop, your smartphone, any portable device without paying a lot of money for it. You can record programs for later viewing, and you could do all this in a handful of cities where its service was running, at least until the Supreme Court decision, for somewhere between $8 and $12 a month. So if you were in New York, you could watch whatever's being shown on the ABC, NBC, CBS, Fox affiliate. And it sounds like a great idea. The company used these, as I said, dime-sized antennas, and which it would house in a warehouse, in the case of New York, over in Brooklyn. And when a subscriber wanted to watch a program, Aereo would simply assign one of these antennas to this subscriber, and only to this subscriber. And in so doing, Aereo said it wasn't really any different from sort of the old-fashioned way of watching television with your rabbit ears or your aerial antenna. It was you making a decision to watch a particular show and just utilizing Aereo's equipment to do it. As I said, it sounds like a great idea. The only problem, the network said, is that Aereo could provide this service for so little money, only because it was essentially stealing their broadcast signals, at least taking them without paying the same sorts of fees that cable systems do. Just a quick little background. In a pair of 40-something-year-old decisions, the Supreme Court said that the precursors of today's modern cable systems were not violating the network's copyrights when they set up huge community antennas and then strung cable from those antennas to subscribers' homes in places where it was difficult to get local television reception. Well, in 1976, Congress changed the Copyright Act to make that, in fact, an infringement of the copyright. And then from there ensued a series of fees that the networks can collect from the cable system providers, and they are quite substantial, in the billions of dollars today. A few years after the Copyright Act was rewritten, a case involving another aspect of the law was the case of the Sony Betamax machine, as many of you may remember. It was an old-fashioned way of capturing television programming and watching it when you wanted. The television networks and the movie studios sued and said this would be the end of our way of life if Sony were to win. And by a 5-4 vote, Sony though did win the case, and it allowed people to make a copy of whatever was being broadcast at home to watch whenever they wanted. Fast forward 20 or so years, and Cablevision, a cable TV system in the New York area, came up with a way of allowing you to make copies of programming for which you had already subscribed to their system, not on a machine in your house, but in a remote way. You could use their remote DVR system. Well, the television networks sued over that, and the Court of Appeals in New York said that that was okay. A few years after the Cablevision ruling, along comes Aereo, and it put about $100 million into building its system. And its system is designed to allow people, as I said earlier, to watch the local programming, but more broadly, it's designed to appeal to a small but growing number of what are called cord cutters, people who don't want to be tethered to their cable boxes and who don't want to pay the high fees that you have to pay sometimes to get television. So that was the fight at the Supreme Court between Aereo and the television networks. And as in the Betamax case, the network said there's nothing less than the very existence of broadcast television at stake. And Aereo said, as Sony did, if we lose this case, you will stifle innovation, and you don't want to do that. Well, by a 6-3 vote, the court sided with the networks. And it said, in an opinion written by Justice Breyer, that, you know, come on, this really looks a lot like a cable system. You provide all this programming to your subscribers, and you're not paying any fees for it, and that's not right. And Justice Scalia wrote a dissenting opinion, and I just want to pause here and just say a reporter's thank you for Justice Scalia and his dissenting or concurring opinions, because over the years they've provided us with a great deal of copy. This was a case in which he wrote that we came within one vote of declaring the VCR contraband 30 years ago in the Sony case. He said this was a case where the court said It was not going to do much damage to innovation, but he wouldn't be so sure. Justice Breyer, in his opinion, went out of his way at several points to say that people were quite worried about what effect the court's decision might have on the cloud and the enormous investment in cloud computing. And he went out of his way to say that really this decision was not intended to do any damage whatsoever to that. It was really just to apply to area. This is another of the cases that have come up at the court, and you might hear more about this in a couple of minutes, where the justices sometimes raise questions about their grasp of technology. This was an argument in which Justice Scalia seemed not to understand how HBO, for instance, is delivered, and wondered if people could just watch HBO on the area system. The only other thing I'd like to say about this case is that the fix may have been in early on, because in a dissenting opinion in the lower courts, Judge Chin called this device that Aereo had come up with a Rube Goldberg-like device. And it was an image that really stuck and was talked about during the argument. And Justice Breyer, although he didn't use the words in his opinion, clearly embraced the notion that that's what in fact it was. Thank you.
Well, thanks for inviting me to be part of this great event. It's really neat to see so many people here. I don't think you can have any one theme that covers a term in which the court decides 70 some odd cases, or even when it decides, or even if you look at this, the top shelf cases. But the one theme I thought I would just mention before talking more specifically about Riley, the cell phone decision, is the theme of tradition. When a constitutional case goes up to the court, there's a variety of tools in the toolbox for the lawyers and the justices to deploy, the text and history and structure. This term featured a few cases that really, I think, forced the justices to grapple with the usefulness and importance of tradition. In other words, how persuasive is it to go to the court on a constitutional question and simply say, well, this is just the way we've been doing it for a long time. It can't be unconstitutional. And when I say that, I mean the way we've been doing it a lot of times since the founding of the Constitution. This is not an original intent notion. This is just a notion that for decades we've been doing it this way, so it must be okay. This was the core argument of the majority in the Town of Greece case that Dahlia talked about when it came to legislative prayer. It was also, on the other hand, the core argument of the more liberal wing of the court in a case we haven't yet talked about, Noel Canning, that involved the presidential recess appointment power, where Justice Breyer's opinion stressed that for decades and across administrations, this power had been used the way that, at least at its core, the way that President Obama had deployed it here. And it was also the argument the government made in the cell phone case, that for years we've been arresting people and being allowed to search whatever it is that's on them. The court was persuaded by the tradition argument in the first two cases, of course, and not in the third case, and I'll talk more about that in a minute. But I think it's fair to say that the court did find itself persuaded quite a lot by the importance of tradition, unless the court thought that the world truly had changed and there was a real reason to depart from that tradition. And interestingly enough, the only justice in the majority of all three of these cases was Justice Kennedy. And as we look ahead, and perhaps not very far ahead, to the gay marriage cases coming down the pike, tradition will of course be at the center of those cases. And the question that Justice Kennedy might well be asking himself in light of the way these cases transpired is it a good enough argument to say that this is the way it's been, or has the world changed in a way that I ought to stand up and take notice? So let me talk a little bit more about Riley, the cell phone case, and I should first do that by way of disclaimer. I represented Mr. Riley in this case, so you can take my comments for what they're worth. Maybe I have hopefully a little bit of insight into the case, but I was not an impartial observer either. So These cases raise the very simple question under the Fourth Amendment, which prohibits the government from engaging in unreasonable searches and seizures, of whether or not the police, when they arrest somebody, can search the digital contents of any smartphone or, parenthetically, any tablet or laptop that the person has on them at the time of their arrested without going and getting a warrant first. Now, this case is argued against the background of decades of law, most notably in 1973 in a case called Robinson, where the Supreme Court had held that when you're arrested, the fact of the arrest is enough to automatically allow the officer to pat down, seize, and search anything that's on your person or that you're carrying in a purse or briefcase or the like. So the argument in this case was, are cell phones different? Now, what the state of California, consistent with what the Supreme Court of California had held a few years earlier, along with the federal government argued in this case, is that no, cell phones are no different. They're just another container of information. And just like we can search a purse or a briefcase or a wallet, we can search a cell phone that we seize from an arrestee without getting any kind of judicial approval to do so. And the government added, kind of as a fallback, that even if we have to show something more than the fact that just somebody is arrested and they're carrying the smartphone, we have particular worries about smartphones because of the potentially ephemeral nature of digital information. They can be remotely wiped by Confederates or preset programs, or perhaps encryption that can kick in to smartphones could prevent us from getting access to it later, so we need to be able to search the cell phones right away. Our response to these arguments were, no, cell phones are different, and therefore the government should have to get a warrant unless there's what the Fourth Amendment recognizes as exigent circumstances. So if there's truly an emergency situation, either because there's a bomb about to detonate or because of the particular technological problem that might be present, that the officers might need to search it now instead of a couple hours from now, they ought to have to go get a warrant first. And ultimately, the court issues a 9-0 opinion in this case by Chief Justice Roberts. And this is the case in sort of contrast of what some of the other panelists have talked about. This is the true, genuine unanimity case of the term, at least among the headliners, because not only did all the justices agree and sign on to a single opinion, but that opinion, I think is fair to say, is a fairly broad sweeping opinion. It's not narrow in order to get a majority. It actually accepted the broadest version of the argument we made to the court, which is police have to get a warrant unless rare circumstances where an emergency type situation exists. And as the court pieced through this argument, because it issued a single opinion by the Chief Justice, which I'll refer to a couple times in a minute, it may be more helpful for you to understand the array of viewpoints for me to just remark a little bit about oral argument, because that is where, instead of just a single justice, many express their views. And I think as I thought about the case, and clearly as the court thought about the case, one way to think about it is they were really grappling with a problem that lawyers grapple with all the time, is that the problem of analogy. When we have a new problem or a new situation that arises, the most ordinary tool that lawyers have is to look at old cases or look at old precedents or old other statutes and analogize this situation to others, and then ask ourselves, well, then how did let's find the best analogy and then move that law over to this new situation. But there's a few different ways to do that, and they kind of came out at the court. So first, there's the originalism mode of analogy that Justice Scalia and Thomas most often deploy. And you might say at first blush that that's a sort of ludicrous way to approach a case about a smartphone. What would James Madison have thought of the smartphone? On the other hand, while right as I was starting to brief this case, I have a 5th grade daughter who I was visiting her elementary school on a day they were reenacting the reasons for the Revolution. And they referenced the general warrants and the writs of assistance power. In other words, the practice of the British of rummaging through a person's entire home upon arrest or other suspicion in order to find anything that might incriminate them. And if you thought about that analogy, it actually applies arguably pretty well to the smartphone context. Indeed, I asked my students when we were working on the case, if you had to give the police an hour in your home or on your smartphone, which would you choose? They were unanimous as well. On the other hand, you could just say, let's look at a more modern analogy. Justice Alito asked at oral argument, well, what if somebody's arrested with a diary in their pocket? Can the police read that, or an address book? And so looking for those kinds of analogies, those are difficult too in the smartphone context, because a smartphone is not just a diary or an address book. It's the equivalent of millions of diaries or address books worth of information. Not to mention all of the other stuff that exists on a smartphone, like GPS tracking data, people that use smartphones to work the insides of their homes or monitor their blood pressure, things that wouldn't have existed in the tangible world before. And that kind of brought, I think, me and my thinking, and ultimately what you saw in the Chief Justice's opinion, to what I think is the most important takeaway from Riley, which is the court ultimately just rejected the concept of analogy in this case and said, digital is different. There's a line in Chief Justice's opinion that says, the argument of trying to compare it to an address book or a diary is like trying to compare a ride on horseback to a trip to the moon. Digital storage of information and the problems it raises are fundamentally different than analog data. And I think going forward, that will be the really interesting thing to watch play out, because the argument the government made in this case was much like the argument the government has made with respect to GPS tracking a couple years ago that also lost 9-0, argument it's making now with respect to the NSA program, which is, we used to be able to do this anyways, and now digital technology just lets us do it better. Or digital technology isn't different in kind, it's just different in degree. And here, an overwhelming majority of the court, indeed unanimously, rejected that argument. And so I think it resets the table certainly under the Fourth Amendment going forward. And I'll be interested to see, and maybe other panelists will have views, even under other areas of law that raise problems of how do we apply the digital world to old analog rules, and will free up lower court judges, lawyers, and indeed the court itself to take fresh looks at these on their own terms and not try to analogize to old solutions that may not fit.
Thank you. All right, I'm going to give the panelists a chance if there's anything burning they want to say. If you do have a question, you can line up at the microphone here at the front. If the panelists don't feel a burning desire to respond to anything, I will go right to questions. And I'll start then as the moderator with the, oh, you have a response.
Just one remark. When you look at Bond and, the avoidance of the constitutional issue, to me, it's not phononymity, it's unanimity. They all said this is a dumb prosecution, and we can get rid of the case that way, so why have a fight with each other? So some of that unanimity, as I said, even about Palm, it's very much drawn to the facts. The court thinks something's good, they're going to find a way to say it's good. When they look at Aereo, they say, looks like stealing to us, we don't think that's good. And they don't care about technology and technology change. They just say, it just looks like a cable system, walks like a duck, quacks like a duck, it's a duck. So a lot of, elaboration goes into these because we as lawyers, and scholars perhaps the same or maybe more, try to find rational explanations or in-depth explanations for things that I think in some measure are really driven by the core reaction of the court. And one could even say about the contraception, the Hobby Lobby case, 5 members of the court who want to talk about natural law think it's bad, abortions are bad, and this is like an abortion, and why the heck should people who dislike it pay for it? And I think you're going to get that thread. And I think what's happened is the public appreciates that sometimes better than the scholars. They see the court that way.
I agree with the characterization that the justices often have a core reaction and then decide on the basis of it. But the danger then is if they're not at all empathetic to those who are different from them, their reaction is just based on their own sensibilities and their own experience. I've long had a predictive principle with regard to the Fourth Amendment. If the justices can imagine it could happen to them, then it violates the Fourth Amendment. If the justices can't imagine it could happen to them, then it doesn't violate the Fourth Amendment. They all have cell phones, and I think that explains Riley. But I worry that that also explains, take a couple examples, Town of Greece versus Galloway, and Burwell versus Hobby Lobby. The majority, all the Catholic men, just aren't very sensitive in town of Greece versus Galloway to what it feels like to be a religious minority, to be Jewish or Islamic or an atheist, and have to month after month hear the Christian prayers. The 5 just in the majority just don't understand what it means for a woman who can't afford contraception and faces either not being able to have contraception or the fear of an unwanted pregnancy. And so when justices are deciding based on their own reaction, there's really a danger that deciding based on their own life experience and perspective. And I think this is a court that really lacks empathy for those who are different from them.
Let's hold the applause to the end, and then we'll give a rousing standing ovation. Mark.
Irwin, I wanted to sort of get your view on the Kennedy's concurring opinion in the Hobby Lobby case, because it set out what at least could be read as a pretty strong limiting principle. One is that it assumed, as did the majority, but it assumed much more strongly that it was a compelling, that the government did have a compelling interest in ensuring that women get contraception as a health matter. And more than that, the reason why this particular scheme failed is because the government, of its own doing, had created a less restrictive way of making sure that these women get contraception. That is the accommodation that it created for the nonprofits, which you mentioned.
And here, maybe I should turn to Dahlia, because if you don't mind, or else I can, you wrote a wonderful piece. 3 days after Hobby Lobby came down, a matter came to the Supreme Court involving Wheaton College. It's a religious college in Illinois. And it fits into the second of the 3 categories of entities that I mentioned. One is the religious institution itself. The second is the nonprofit affiliated with the religion. And the third is the for-profit company. And Wheaton College would fit into the second. And Wheaton College would seem to fit into exactly what Justice Kennedy was talking about in his concurrence, or what Justice Alito referred to as a less restrictive alternative. And so it would seem that the majority of the court, especially Justice Kennedy, but also Justice Alito writing for the court, would say, this second alternative for a nonprofit religion is fine, just have them sign this 2-page statement. Well, the court, in a 6-3 ruling, it was not obviously a decision, granted a preliminary injunction for Wheaton College, which means they had a substantial likelihood of prevailing on the merits that it would violate the Religious Freedom Restoration Act to require them to sign this 2-page statement. In other words, the very less restrictive alternative that the court approved on Monday, it seemed on Thursday indicate was illegal. Dahlia, I think you referred to this as something like a bait and switch. Dahlia wrote a wonderful piece in Slate about it, which is why I was going to turn to her. And then the court said, is its own alternative, they could just write a letter rather than signing the 2-page statement. Maybe I'm too simple about it, but I don't understand why signing a 2-page statement would violate the Religious Freedom Restoration Act, but filing a letter would not violate the Religious Freedom Restoration Act. There's a distinction there that I just don't get. But the reason, Mark, I think this answers your question is that this intermediate alternative that Justice Kennedy endorses that you referred to, you've at least got 6 votes on Thursday that say that there's a probability that it too violates the Religious Freedom Restoration Act.
While you respond, Dahlia, could you also speak about the position of Justice Breyer, the odd position of Justice Breyer being a dissenter in Hobby Lobby and then apparently agreeing, although we don't know, in this case? Someone said maybe he got into a bike accident and missed the...
Yeah, no, I mean, we don't know that, I feel that we don't know that there were 6 that signed off on the injunction, and I told people he was in France and his wife wouldn't let him come to the phone. I don't know why he, I mean, I really, we don't know where Justice Breyer was on the Wheaton College order. You know, and I think in a way, it's extra poignant that the dissent from the Wheaton College order therefore comes from the 3 women on the court, written, you know, Sotomayor writing very, very, very strongly, in fact, saying that it really undermines the legitimacy of the court to do, you know, to sort of, in effect, bless the accommodation as the least restrictive alternative on Monday, and 3 days later to say, oh, wait, this also violates religious conscience claims. So I just want to point out, I mean, I don't disagree with anything that Irwin said. I read Kennedy's concurrence as more or less saying, you know, this is a case without a limiting principle. the limiting principle in Justice Alito's opinion, as I understand it, is, trust us. It's not going to get crazy. It's hard to really see how, when Justice Ruth Bader Ginsburg in her dissent sort of unfurls her parade of, she calls it, the court is just going to walk into a landmine here, and all these things are going to happen, and the answer seems to be either it's not going to happen because it's not in corporations' interests to do this, or it's not going to happen because we say so. And I read Justice Kennedy's concurrence as saying, no, we really mean it when we say it's not going to happen. In other words, it's an assertion that backs up an assertion, but there isn't really a sense, other than, the assertion that there is a compelling interest, and I think that does matter, that Justice Kennedy says, because Justice Alito doesn't, he concedes it for argument's sake, but doesn't concede it as a legal matter, that there's a compelling interest. But I think really for me what was deeply worrisome about this case, and much as was the case in the town of Greece, where you saw the court split on religious lines in town of Greece, and you saw it split on gender lines. And I think that it raises all these really difficult questions about the extent to which race and gender and religion inform judicial decision-making, and watching that play out publicly is very, very discomforting for people who struggle with how much that should matter.
All right, so since there's no one lining up yet with questions, I'll start with a question from Twitter. Henry, you can queue up right here. And the reporter and you, I know you can't resist. This is a question from Michelle Olson of Appellate Daily. Yesterday, and I'm embellishing beyond the 140 characters to give some context. Yesterday, the Utah Attorney General announced that they were not going to seek an en banc review of a 10th Circuit opinion which held that Utah's ban on same-sex marriage violates the U.S. Constitution. Instead, they were going to go right for cert to the Supreme Court. And Michelle's question is the court going to take that case? And part of the question, I think, there is there really a circuit split, which is ordinarily the reason we've had kind of this unanimity since last term's Windsor case, with every court, I think every judge but one on all of the courts holding that the same-sex marriage bans do violate the Constitution. That's open to anyone?
I guess I made a reference to that, so it strikes me as quite likely the court will take the case. I think the court often looks for disagreements before stepping in, but the court also is quite sensitive to the notion of federal constitutional law being used to invalidate state laws. And so when a state attorney general comes up, even in an ordinary case, and says, a federal court of appeals has told us that our state law is unconstitutional, the Supreme Court takes that very, very seriously. In this particular context, I think it'll take it all the more seriously. So really the question then becomes, is there some matter of sort of strategy or game theory among the justices that is going to produce a big enough majority to simply just kick the can down the road? Your guess is as good as mine in that respect, whether the justices who might be in favor of saying there's a constitutional right to gay marriage think that they should take their time right now while the wind's at their back, whether those who are against it think we better take the case now because it's not going to look any better in the future, the numbers are only going to grow, or whether the court as an institution or enough of a group of them are going to say, we're just not quite ready to do this and want to let the world play out a little bit longer. And I think that's the kind of questions they'll be asking themselves. Only the justices themselves can decide, though. It's the fascinating aspect of the court's discretionary jurisdiction.
And any predictions about what the court would do if it does take the case? Irwin, you're nodding your head.
Yeah. I think 5-4, the Supreme Court would affirm the 10th Circuit and say the Utah law is unconstitutional. I think Justice Kennedy's opinion from Windsor would outline exactly what the court would do. In fact, if you look at Justice Scalia's dissent in Windsor, he took Justice Kennedy's majority opinion, just crossed out lines there and just substituted state law. There have been 3 Supreme Court cases in American history advancing rights for gays and lesbians. Romer v. Evans in 1996, Lawrence v. Texas in 2003, United States v. Windsor in 2013. All were written by Anthony Kennedy. My bottom line for prediction, if nothing else, is that for justices like Kennedy and Ginsburg, Breyer, Sotomayor, and Kagan, they have to ask, do they want to write the next Brown versus Board of Education or the next Plessy versus Ferguson? There's no doubt where history is going on this, and these are justices who want to be on the right side of history.
And I might add, I just might briefly add that I think that to the extent that there is an anxiety underlying the court's timing, or, you know, what Jeff's calling game theory, I think the anxiety is kicking up a backlash. And, you know, Ginsburg has been really open about saying, you know, oh my God, Roe v. Wade, you know, it fomented such dissent in the country. We don't want to get out ahead of the country. And I think what changed between Windsor and what's going to happen when the court takes this case is that, as Irwin says, the wind is at their backs. Every single case that has looked at this has held Windsor to mean what Windsor wasn't willing to say, which is we're going to take the next step. We're going to pull the trigger that Kennedy wasn't willing to pull. And so it just seems to me that to the extent that what the court was worried about was getting out way ahead of public opinion, I think now they can comfortably say public opinion has changed, you know, gone from 0 to 120, even as between when Windsor was decided and when this case comes to the court.
Yeah, I would, you know, I think that one thing the court's got to look at is its public reputation. Here, it's not just the winds at their back judicially. It is that public opinion is radically shifting in favor of according a right to gay marriage. So I think the court might just say, you know, the bigger that gets, the easier it will be to decide this case. And, you know, so rather than start the backlash today, why don't we just wait a little while? By that time, it'll be a non-issue because what we vest constitutionally will already be accepted socially. And I think that matters to the court. But that's just a guess. The interesting question is, if a state passed a law that said anybody licensed to conduct marriages in this state should be compelled to marry gays. And under your principle, I guess the answer would be that's okay, but I think under the Hobby Lobby case, there would be a severe question on the Religious Freedom Restoration Act.
And I actually think it's interesting that you mentioned Romer, and it's interesting to think about Romer and Sheedy and Kennedy's approach to those 2 cases, because you see very different approaches and an ironic edge to that, where it seems like his approach in Romer was much more sympathetic to the application of the Equal Protection Clause in a context that looks very similar to the Sheedy context, and less sympathetic to the application of the Equal Protection Clause in the race context, when arguably that's where the Equal Protection Clause should be doing most of its work. So it's interesting to think about Kennedy's role there, too.
Whether this term was or was not a dud, last term, Mr. Rhine argued 2 cases that were clearly not duds by anyone's imagination, Shelby County and Fisher. And as somebody that argued those cases, I was wondering if you could just talk in particular about what has happened in the aftermath of the Shelby County voting rights decision, whether anything that has happened has surprised you or you've had any second thoughts about it. And I'd also like to invite Professor Hassan to comment on this as well. Thank you.
Well, I mean, I'm not tracking these cases, you know, in a political science mode and saying what happened as a result of Shelby. I mean, clearly you had movement in the country to, from one party's perspective, ensure that only the people who actually qualified to vote would vote, and movement in the country saying, well, that's, you know, going to cut out, there's too much type 2 error, type 1 error, and that you'll cut out people who should be voting, who just don't have the credentials. I think that movement was independent of Shelby because it was taking place in states other than the states that were subject to pre-clearance. You know, I think, again, the real politic, if you will, kind of governs. If you look at Mississippi, you know, if you wanted to find the paradigm case of they ought to be subject to pre-clearance, right, it's Mississippi. So what's happening in Mississippi? The weight of the minority vote is such that the Republican candidate, right, who wants to hold his office is out there appealing to the minority. And the real lesson of it is, you know, there's a point of transition. Yes, you may need federal supervision. There's a point where when people register and vote and become significant members of the community, they will get the political respect. I think that's what's happening in the country. People have turned to say, there's no question that the courts, government will enforce my right to register and vote and have my vote tallied. Once I have that right, then it's all about organization, and that's what Obama proved. It's getting out there and doing it. The more you prove you're going to do it, the more the political winds will take. And that's particularly true, I think, of Hispanics in the country. Everybody is looking at, how do I get their vote? So that may be a better solution.
Or how do we stop them from voting, if you ask some people?
See, and I don't think that's realistic. I think that, yes, on the margin, you can make it more difficult, but if you looked at real numbers, there's increasing voting of that kind, and the more effort you make, the more vote there'll be. And I think a lot of what this court is deciding in a lot of these cases is sort of individualism. I mean, the attitude on Town of Greece is, you know what, get over it. You don't want to listen to the prayer, be like everybody else. Nobody really listens to those prayers anyway. I mean, I think that's in their heads, and that's a kind of realism. And I think in the Hobby Lobby, I think the court was influenced by saying, well, Hobby Lobby is really kind of a religious corporation. You can't do it by the identity. Yeah, they're incorporated, but many religious congregations are incorporated. And I think if you look at their purpose as, well, they got together to do business and they suddenly assert religious rights, it's one thing. But Hobby Lobby's, I think in the eyes of the court, a different proposition. They're really committed people, and they're not using it as a facade. So the court's kind of saying, well, what if they ran it as an LLP or a partnership instead of a corporation? Would that make a difference? Should we do it on an artificial use of a legal mechanism, or do we want to respect individual rights? I'm not saying a case is rightly decided, but I think there are very tough questions if you say anytime you take advantage of a legal form other than individual proprietorship, you're out. You can't assert other rights. I think that's not where the court's going to go.
Just to come back to Henry's original question on what's happened in the country, Bert says he's not following it as a political scientist, but last year on the panel, Adam Liptak of the New York Times described me as America's #1 election obsessive. So I do follow this stuff very closely, and what I can tell you is that there have been a lot of changes that have happened in jurisdictions that used to have to get federal approval for their voting changes. Within 2 hours of the Shelby County decision, Texas announced it was going to enforce its strict voter ID law, the law that says that it's unconstitutional, you can't vote with a student ID, but you can vote with a concealed weapons permit. A few weeks later, North Carolina passed what I consider to be the toughest set of voting restrictions we've seen anywhere in the country since the passage of the 1965 Voting Rights Act. 40 counties used to be subject to preclearance. Just this week, the Justice Department and private plaintiffs, civil rights groups are trying to get a preliminary injunction to stop some of that law from going forward. None of these laws would have been in place. Augusta, Georgia moved its election from November to the summer. Couldn't have done that without federal approval before. Pasadena, Texas, where there was increasing minority, Hispanic minority districts, moved to no district elections. So there's been a lot of change, and there's a lot of lawsuits under other provisions of the Voting Rights Act, and one question is how they're going to fare since Shelby County. But there's been a lot of change since then.
Can I just respond? And then I will be brief and hopefully controversial. But I think I want to knit together what Bert is saying with what Irwin said before, because I think they're both quite right about the notion that we now have a sort of jurisprudence of like, get over it, or we're over it. And it's quite worrisome insofar as I think when the majority of the court is saying, just suck it up if you don't like legislative prayer, just don't feel coerced and get thicker skin, is the same majority that might not say, get over it if an imam was leading the prayer, or if a Wiccan, God forbid, in their view, was leading a prayer. And the problem is, I think it reinforces the status quo. The status quo that goes to Irwin's point about this is in the justices' notion that, it is just so that if you've been sitting and listening to sectarian, primarily Christian prayer for years and years, you should just kind of get used to it and not be bothered, reinforces the very idea that it seems to me the First Amendment is supposed to not allow for. And so I think in all these cases, including Hobby Lobby and Town of Greece, it's really important to just do the thought experiment of what if it was not, a Christian family company that really does deeply believe that they are experiencing religion and in fact exercising religion because they play Christmas music and they are closed on Sunday and they live their values and no one doubts that. But if this was a deeply religious Muslim family or a deeply religious Jehovah's Witness family, and it's not familiar both to us and to the justices, then it's a harder case to just say, just get over it. And that's, I think, the problem with making decisions based on your own sense of empathy with what you're used to.
Can I just add a couple of things about the town of Greece case? One is that, of course, the Obama administration was on the side of the town of Greece, which is just an interesting point. And I think the other point that's worth mentioning is that all 9 justices agreed that a legislative prayer embodied in the court's decision, 30-year-old decision in March, was okay. There was a sharp disagreement, obviously, over the sectarian nature of the prayer here, but there was that. And lastly, to Dahlia's point, I guess we'll get some signal about this in the coming term in the case over the rights of the Muslim prison inmate in Arkansas who has been ordered to shave off his beard, and the court has agreed to hear that case next term.
Oh, take the final question, Bruce. We're almost out of time.
Hi, thank you very much. I'll make this very brief. I want to first thank Dean Chemerinsky for bringing, I think I speak for all of us, for bringing together such an outstanding and such a personable panel. I'm very impressed on both counts. I had a question in a case that hadn't been discussed yet by this illustrious group, and that is Harris against Quinn. I'm wondering what you all thought, or any of you, given time, maybe Annie instead of all, might think of the implications of this decision, whether it was a narrowly confined decision for a group of home caregivers seeking to opt out of a union, private union organization, service employees union, international service employees union, in regard to Medicaid benefits, their compensation under Medicaid, which statutorily is a rather limited area. But what are the implications in a broader sense for the exclusive representation rule for more established unions, particularly California Teachers Association, which I'm a member, having to do with that opting out now as compelled speech, roughly under the compelled speech doctrine. And even further than that, Larry Tribe in his new book talks about maybe the next step beyond, getting rid of the exclusive representation rule. What implications might this have for shareholders in a corporation? Having a law that requires at least a majority of the shareholders to agree to political spending by the corporation.
Well, there's a lot in that question. We don't have a lot of time. I'm going to ask. No, that's a great question. I'm going to ask Irwin because he speaks faster than anyone I know.
In 1977, in a Bood versus Detroit Board of Education, the Supreme Court held that no one can be required to join a public employees union, but that non-members have to pay for the collective bargaining activities that they benefit from. Non-members of the union still benefit in terms of the wages, the hours, the working conditions, and the representation. And so over a series of cases, the Supreme Court said that non-union members can opt out of supporting the political activities of the union, but still have to pay their fair share for the collective bargaining activities. 2 years ago, in Knox versus SEIU, the Supreme Court decided a question that hadn't been briefed and argued, and the Supreme Court, in an opinion by Justice Alito, called a Bood into question and said that non-union members should have to opt into supporting the political activities, that opt out is not good enough. Harris versus Quinn is very much a follow-up to Knox. Harris versus Quinn involves an Illinois law that involves home health care workers, personal assistants. These are individuals who are paid by state Medicaid funds and provide personal home care to individuals. State law says that they had the right to unionize. They voted to unionize. And under the usual rules of a Bood, the non-union members would have to pay for the collective bargaining activities of that union, but not have to pay for the political activities of the union. Some non-union members who didn't want to support the collective bargaining activities brought a challenge to this, including asking the Supreme Court to overrule Abood. The court did not overrule Abood, but declared the Illinois law unconstitutional as violating the First Amendment rights of the non-union members. Justice Alito wrote the opinion for the court. The opinion was joined by the other conservatives, Robert Scalia, Kennedy, and Thomas. Justice Kagan wrote an impassioned dissent joined by the other dissenters. Justice Alito's majority opinion reads for a long time as if the court was going to overrule Abood. It is very critical of Abood in requiring non-union members to pay their fair share for collective bargaining. But then he says we don't need to overrule Abood. We're not going to extend Abood to this kind of worker. He says these are just quasi-government employees. They don't all work in one workplace. That we're not going to take the usual principles of Abood and apply it to this kind of a statutorily created situation. Justice Kagan's dissent strongly defends Abood. She says there's thousands, tens of thousands of public employee contracts that have been formed on the basis of it. The question is this the step to overruling Abood that, say, the National Right to Work Committee wants? Or is it that if there were 5 votes to overrule Abood, the court would have done it here, and it doesn't do so? There's no doubt this is a blow to labor unions. How big a blow, we're not going to know until the future.
Well, rather than ending with a sectarian prayer, I would like to end with some applause for our great panelists today. Thank you very much for coming. We'll see you all next summer at the 5th annual UCI Chairman Review event.